The minority in Parliament have been in the news for a number of reasons, commenting on many issues, particularly the petitions that have been forwarded to the President for the removal of the Chief Justice. Of course, some of the minority MPs from the Ashanti region have also commented on the words used by the mayor of Kumasi, threatening to beat up errant traders who hawk on the streets. We're speaking to Bafo on that and other matters. Of course, the MPP itself received the Professor Mike Okwe committee report and set up a constitution review committee to look at aspects of the MPP's constitution. Lawyer Naneje Bafo joins us to share some light on all of these matters. Thanks for joining us, Honorable Bafo. Good evening.
Welcome, my brother, and thanks for having me. Good evening to you and your cherished listeners.
So the minority has been concerned about the moves to essentially oust the CJ based on 3 petitions. And I think the last we heard was your colleagues asking for chiefs and the clergy to get involved. How did we get here? Why do you think chiefs and clergy should get involved in this matter to impress upon the president? Because some would say the president is following the duly laid out process in Article 146.
Yes. I think that it's a bit of constraint in terms of the hearing. It's difficult to hear you.
Okay, so I wanted the minority's view on where we were with the CJ petition and all that's going on.
Thank you very much. We think that this is a matter which we need to tread cautiously. That being the case, we need to constantly.
All right, we have a challenge with Bafo's number. I'm going to give you some highlights of what the MPP have said while we raise him back on the line. So the minority parliament has called on religious and traditional leaders to counsel the president, John Dramani Mahama, to suspend proceedings aimed at removing the Chief Justice, Her Ladyship Gertrude Tokonu. According to the caucus, the petition seeking the Chief Justice removals are unfounded and failed to meet the constitutional requirements for removal. So I have Lawyer Bafo in studio with me. A lawyer, welcome to the show. Good evening.
Thank you, my brother.
So I was asking why you opted to ask chiefs and religious leaders to join at this stage, where some would say the processes in Article 146 are being followed, at least on the face of it. If you look at what the president is doing, on the face of it, it seems as if he's following that process. So why is the minority going to chiefs and religious leaders at this stage?
Thank you very much, Bernard, and I'm sorry for the delay. There's thick traffic on the road.
It's part of Accra life.
My brother, there's something we all need to advert our minds to. It is not necessarily the procedure. It is also about the potential outcome. And if you advert your mind to the grounds for the removal of the CJ, you will notice something. You will notice that even though the grounds are stated there, what accounts, for instance, to stated misbehavior? What accounts to, for instance, incompetence is something which is left to the good sense of the President and the Council of State. And the Constitution was deliberate about it. It's just like what accounts for the qualification upon which someone may be appointed a judge or the Chief Justice. You realize that there's a bit of latitude in there. And, you know, I always say that when it comes to these matters, you know, I'm always reminded of what Justice Pega said in the case of Attorney General versus Justice Aban in 1995 concerning a case where the Ghana Bar Association wanted Justice Aban to be removed effectively, because post his appointment, they were challenging it. And so effectively, it would have resulted in his removal. Justice Aban, Pega said something which I would want to read, if you don't mind.
Go ahead.
It says the Constitution is silent on who a man of high moral character and proven integrity is, and the factors to be taken into account in finding such a person for appointment as Chief Justice of Ghana. The framers of the Constitution 1992 have deliberately left these matters to the good sense of the President, the Council of State, and Parliament. Right? In the same token, what constitutes stated misbehavior, like I said in my opening remark, is unknown. And what goes into it, what accounts for it, is also unknown. And so very much heavily depends on the President and the Council of State at this point, right? And all we are saying is that, look, if there isn't anything grievous, let's not touch the Chief Justice, because we risk making the judiciary a subsidiary of the executive. When the grounds, right, when the elements of the grounds for the removal of a judge is left to the good sense of the President, it's left to the good sense of the Council of State, right? In the case of a judge of a Superior Court of Judicature, it's left to the Chief Justice, right? If you are not careful, right, every judge will operate under fear, because he then knows that if he is not careful, he may be removed at the least opportunity, right? And so let us tread cautiously. If what you have before you, especially because what you have before you, right, I mean, when I refer to you, I'm referring to the Council of State and the President. If what you have before you is not that weighty, let's tread cautiously. Now, we are also concerned because you cannot isolate this from commentaries that came out prior to the elections. Nobody in this country, right, is unaware of the position of the NDC prior to the elections concerning the judiciary. It's a matter of public knowledge. And so when you are dealing with a process which constitutionally is in camera, right, for which reason some of the information you have, they are grapevine information, right, all you can do is to appeal to the good conscience of the actors that, look, let's be careful, let's tread cautiously. If it is not something that borders, for instance, on corruption.
Fair enough. But to the extent that we do not know or are not supposed to know what is contained in these petitions, can we not say that your side is being prejudicial in the sense that if you had said, Mr. President, proceed cautiously and stick to the law, Council of State, exercise good judgment in your proceedings. If there's a committee formed on the basis of a prima facie case, committee, do your work with the level of professionalism required. That would be fair. But if you are asking the religious leaders and the traditional leaders to counsel the President to suspend the proceedings, are you saying that you've seen the contents of the petition and they are without merit? Or you're just saying that because of the potential implications of a president overseeing the role of a CJ, whatever the allegations are, he should stop?
No, you can look at it from two perspectives. One, what I said in terms of what you have picked up from the grapevine. In the press conference, if you recall, one of the things that was stated was the fact that as part of the petition, you have someone saying that he was cited for contempt, right, before the Supreme Court, and the CJ was the one presiding. Okay, now, for a matter such as this, if it is part of a petition, a president that has presidential, that has a council, right, a president that has the benefit of an attorney general, right, should be able to know that such a petition shouldn't go far. Why? To begin with, the CJ was just the president of the panel, right? And so she cannot be solely held responsible for a panel which is supposed to have an independent mind. It is not like at CTFM, very respectfully, where Bernard, you are the MD, and so the back stops with you.
General manager.
I
see you.
Sorry.
I get the point.
General manager. So the back stops with you. No. When it comes to judicial decision at that level, every judge is responsible for his position, which is why the opinions of all the judges are sought, right? Secondly, we know that you cannot take disciplinary action against a judge for his opinion on a matter of law. Okay? Because a judge is entitled to also err, which is why there are appellate processes. Okay? And so if a judge, for instance, errs in terms of a legal position, be it procedural law, be it substantive law, you cannot on the basis of that say that he should be dealt with. You are looking at a chief justice. Who, apart from being a lawyer, right, was a judge of the commercial court for a very long time, right, was a judge of the Court of Appeal. She was appointed a judge of the High Court, right? Subsequently, at the Court of Appeal, elevated by President during the NDC's, one of the NDC's tenures, and subsequently taken to the Supreme Court. Right? And so it's difficult for you to come to the conclusion on the mere basis that you were cited for contempt or referred to the General Legal Counsel by the Supreme Court, and so there is.
But are you not doing the committee's work for it, in the sense that we have not seen the full extent of the 3 petitions, and we do not know the substance of those, which is why the Constitution is very careful in 1468 that all proceedings under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard in his or her defense by himself or by a lawyer. My point is, in your attempt to stop what you consider an injustice, you may actually be doing the CJ more harm by discussing what you have seen or gleaned of the petition, because the framers were very clear in why they did not want those matters out. And in the way the minority is proceeding, you may actually inadvertently be hurting her reputation.
You know, is the level of discretion involved in this matter, right, against the backdrop of prior commentaries, which is breathing this kind of apprehension. So even if it is not a case for suspension of the proceedings, because obviously the president has his constitutional right, you cannot. All we are saying is that tread cautiously.
Fair enough.
There's a risk. Because, look, the provisions are such that there's a lot of latitude for you to play with.
So the problem is the Constitution.
The problem is the Constitution. But the Constitution, I always say that. You see, sometimes when people say Ghana's Constitution needs amendment, I always say that the Constitution was made for men of good conscience. You see, it was, because if it wasn't, then you would have had an extremely voluminous document, the distance of Accra to Kumasi or Tamale,
just to check the abuse of discretionary power.
Exactly. But because it was made for men of good conscience, for instance, in the appointment of judges, you have, let's say, men of proven integrity. It doesn't, for instance, tell you, as I said, the factors, but it is expected that between the president and the Council of State and the president and Council of State, it's expected that they will be able to tell whether a person is of good conscience or not. It is expected that between the president and the Council of State, they should be able to tell whether this petition merits, right, the removal of a judge, of the Chief Justice, in which case you say a prima facie case has been established. And so in that circumstance, we are saying that the very actors involved, please tread with caution.
I think that's fair enough. And since the developing story, we would leave it here for sake of time.
Yes.
But hope to talk